Hi, everybody. I'm Tran. Today, I'm going to go through a typical settlement approval process for a collective action overtime case. To help me make the point and explain to you the different ways that collective action overtime cases are evaluated, I'm going to borrow a ruling from a district court judge from the Eastern District of Texas, Sherman Division, Judge Mazant. So this case is called Troy Cunningham versus the Kitchen Collections, LLC. This is a court approval order from 2019. It is a memorandum that adopts a magistrate's analysis and approved of a plaintiff's counsel's motion to approve a overtime case that had settled. The settlement included payment to the class members. Number two, it includes enhancement award to the class representative and an opt-in member or an opt-in plaintiff that assisted the lawyer in prosecuting this case. Number three is that this order also awarded attorney's fees at $600 an hour. So let's break it down. The first part is, as you can see here, the court explains that generally in Fair Labor Standards Act, or FLSA for short, the claims must be reviewed and approved before the case could be settled. The Fifth Circuit Court of Appeal has made some exception for this because the Fifth Circuit is a little different. Let me first break down what the Fifth Circuit is. The Fifth Circuit Court of Appeal is an appellate court that oversees all federal district court in Texas, Louisiana, and Mississippi. So the first thing is the courts look at whether or not there's a bona fide dispute over the hours or compensation owed or exists. What this says is that the courts look at whether or not there's a disagreement on the amount of overtime owed. If the parties agree that there's no overtime owed, no settlement. If the parties disagree on the amount of overtime owed or whether or not overtime is owed at all, the courts make that determination and jumps in and evaluate whether or not in light of the disagreements between the party on if any or how much overtime is owed, the courts will then decide and judge whether or not the settlement is fair based on the disagreement between the parties. Now, what factors does this court look at? Judge Mazant correctly states that the courts often rely on the Federal Rule 23 factors. What is Federal Rule 23? Federal Rule 23 is the rules that the courts look at in adjudicating and evaluating class action lawsuit. Now, FLSA lawsuits are not usually filed as a class action per se. It's usually filed as a collective action. A collective action is different from a class action because the collective action process is found under the Section 216 of the Fair Labor Standards Act. But in evaluating a overtime lawsuit settlement, the courts will oftentimes rely on Rule 23E. And here are the factors for Rule 23E. Number one is the existing of fraud or collusion. The courts want to make a determination whether or not the lawyers have defrauded their own clients or worked and colluded between the two parties to settle the case. And so the courts have to evaluate based on a lot of factors, but whether or not there's any cheating involved. Number two is the courts look at whether or not this case will be expensive, whether or not it will take a lot of time, and the complexity in the overtime case. Sometimes in an overtime case, complexity would mean if the parties, if the employee had misclassified an employee and you had to evaluate their job duties and you had to overlay different federal laws, guidance by the Department of Labor, and make it very complicated. Sometimes the complexity will be entailed in the calculation of damages or the determination of how much overtime is owed in the first place. The factor number 3, the stage of the proceeding. The courts look at how much time has been spent and what has been done in terms of discovery. Discovery is request for information and documents between the parties, and depositions under sworn testimony. The courts look at factor number 4, the probability of the plaintiff's success on the merits. If the plaintiff has a challenging case, the courts will then make a determination that it might be a good idea to settle it. If the plaintiff has a very strong case, the courts may then make a determination that really high settlement, large settlement to the class and plaintiffs would be in order. So the courts look at that. How do you make a determination of what's fair? The factor number 5 is good. The courts look at the range of the possible recovery, whether or not it's a couple $1,000s or hundreds of thousands of dollars per person. The courts make a determination. Well, if the potential recovery is $100,000 and you're making a compromise at $80,000 and the plaintiff's chance of success is really high, the courts might approve it. If the range is between $100 and $100,000 and you're settling it for only $100, the courts look at how strong is the plaintiff's case, what would you need to spend in terms of developing the case in terms of time and money. And the courts may say, well, it's a challenging case for the plaintiff. I'm going to approve a lower amount to settle this case. Number 6, the opinion of class counsel representing the plaintiff is really important, because if you have an experienced lawyer representing the FLSA class, the courts make that opinion of the lawyer an important factor, because if you have an experienced lawyer that thinks that the case should be settled for this certain range, the court will weigh that. So I just talked to you about the first part. Let me talk to you about the second part of a overtime settlement. This is called the enhancement award for the class member. In this case, the named plaintiff received $6,500 and the opt-in plaintiff received $4,000 because both sat for deposition. And so the court recognized that service awards to class representative are permissible as long as they're fair and reasonable. And so you can see ranges from $6,500 to up to $10,000 have been awarded on a regular basis for class counsel to give to plaintiffs and opt-in plaintiffs. So named plaintiffs, opt-in plaintiffs who participate in prosecuting the lawsuit, they are entitled to enhanced damages. And so you can see here, the court looked at the factors and said that it's fair and reasonable, considering that those two individuals assisted the lawyer in prosecuting the lawsuit. The third part is attorney's fees and costs. What the courts usually do is they look at the lodestar factor. So the lodestar factor is just two things. One is how many hours did the lawyer and his staff expended? 2 is what is the market rate for that lawyer and his or her staff? You multiply the hours invested in the case by the market rate for that area. And so you may wonder, what is the market rate? Well, the market rate is determined by just affidavits from local law practitioners in the employment field, and particularly in Fair Labor Standards Act cases. In this case, the court recognized that the lawyers expended over 484 hours on the case, and his hourly rate, the court said, was high, but the court still recognized that $600 is reasonable for an overtime case. And so the court multiplied $600 by the hours that the lawyer invested in the case and came up with $230,000. The court also calculated some more time that the lawyer would have to expend to administer the class, meaning to send out class notice, to administer the settlement, to send out settlement paperwork, collects signatures from the class members, and make sure that the class members are paid. The court awarded the lawyer an additional $15,000 to administer the settlement and to make sure that the class members are paid accurately. So in sum, you're looking at, and you can see at the bottom, the judge signed it, and the date's July 2019. And right now, the process still remains the same in the Fifth Circuit and all over Texas. So number one, the courts look at whether or not the settlement is fair and reasonable. Number two, the court looks at whether or not opt-in plaintiffs and the named plaintiff are entitled to enhancement award. And number three, the courts look at attorney's fees and costs. So overtime cases can get pretty expensive. As you can see here, $230,000 in attorney's fees were awarded before the case settled. So there's not a lot of mystery here. It's pretty formulaic in approach. The only difference is the type of information that the parties bring to the case, and why it's kind of unique is different fact patterns arise from under every case, and the judge has to look at it and make a determination it's fair. It's up to the lawyers from both sides to negotiate a fair settlement that passes muster. It serves the parties no good if you negotiate something and the judge will just turn it down, especially when it's kind of lopsided in favor of the employer and the employee's getting a very low amount. The judge will reject that settlement if you don't meet all the factors that we just discussed. If you have any questions, feel free to post a comment below or contact me, and I'll do my best to respond to it.